Carrie?
Yeah. Sure. Generally, our civil liberties perspective is that activities that occur during school time, using school resources, as school functions, the courts have said that's within the school's purview to discipline. But activities that happen completely outside of school, that are not touching on a school activity and do not constitute a threat, that should be outside of the school's disciplinary reach. Certainly there are some schools that have codes of conduct or certain policies. You see it more at the collegiate level than at the high school level, certainly. At the collegiate level, it's a little different because then you have basically a contract issue, that a student signs a contract for an athletic scholarship or something like that. In the high school context, the context matters to a degree. If the school is going to impose an out-of-school code of conduct on all the students, that's, from a civil liberties perspective, that's something that may be problematic. But if it's tied to a specific program, that may be another issue. The courts have said that doing, for example, drug testing for student athletes, even if that's something that the activity takes place outside of school, they might do the testing in school. The courts have said that's okay in that narrow context. So it may depend a little bit on the type of code of conduct that's in place and who it's applying to.
So many questions. Let's start with this. I presume on political speech on T-shirts, you would acknowledge schools can regulate that.
Well, the courts have said very clearly that schools can limit and punish disruptive speech, but they can't punish speech that they don't like or that they think might be disruptive. It has to cause an actual disruption. The most famous case was Tinker versus Des Moines from the Vietnam War era, when some students were wearing black armbands in a protest. That was political speech. It didn't disrupt the school, and ultimately the Supreme Court said that was protected. And that's remained the case. If it's political speech and it's not disruptive, that's protected. Once it crosses the line into disruption, then the schools can limit it.
Define disruption.
That's in the eyes of the beholder.
Okay.
Well, the reality is that disruption is kind of it's case by case. If the school thinks, well, this could cause disruption, or oh my goodness, this might cause students to think and debate heatedly on something, the courts have said that's not enough. You can't shut down speech on that ground alone. It has to cause an actual disruption, chaos in the halls.
The prohibitions you mentioned in the letter,
Yeah.
I take it those are all based on case law?
Yes, and the cases are cited there in the letter.
Police officers, public safety forces, routinely are disciplined if an employee expresses a controversial view on Facebook or private page, off duty, without. Why shouldn't that apply to students?
Well, you have a different relationship. If you're talking about an employer and an employee, you have a very different relationship than an educator and a student, especially because students are, under law, they're compelled to attend school. They have to attend school. So the relationship is very different than in an employee-employee context.
Can you define sexting? I mean, is sexting mainly defined with reference to children, to teens, or could sexting be something between two adults?
Well, sexting is a term of art that's been used to describe behavior, as Brian described, of sending a nude or semi-nude photograph electronically, whether it's using a cell phone or using the internet or some other technology to send it. It certainly can happen within any age group whatsoever, but the law only criminalizes it when minors are involved, because then it falls within the realm of child pornography. So if the photograph is of a minor, then there's a criminal consequence that we wouldn't necessarily have with an adult.
So in the case that you said had been prosecuted before, where a girlfriend had sent a photo to a boyfriend, say for example they're 15, both of them, who is then prosecuted? Are they both prosecuted the same? Are they both looked at? How is that?
There's the potential that both may be prosecuted. One for transmitting, taking the photo, for transmitting the photo, for receiving the photo, for simply possessing the photo. All of those can be treated as criminal offenses.
But they categorize that under child pornography,
Yes.
even if it's kind of a consensual.
Yes. And which is one of the reasons we argue that those laws are not an appropriate fix, and those kids should not be charged under those crimes, because it really is not a perfect fix, and it's not what those laws were designed to do.
I know there was a bill being bantered around.
Not yet. There was a bill, two bills, same identical bill introduced in both the House and the Senate. The House one has had a couple of hearings, but it's still in committee. Neither one has moved yet.
Does there need to be a new law or a section of the code that maybe addresses specifically minors so that they're not prosecuted as sex offenders? Or, I mean, can that change in this state law that's being currently discussed?
Maybe Brian might also like to
Sure.
address that. You know, law isn't always the solution.
Right. There are a couple of ways I think you can look at it. The first one is if prosecutors have discretion in charging decisions, and so if I'm a county prosecutor and I take a look at a case and it's the hypothetical that you propose where a 15-year-old girl or boy sends a nude or semi-nude photo to boyfriend or girlfriend, I look at that and I think stupid,
Yeah.
inappropriate, not criminal. If I have a case where a 15-year-old boy is making the rounds through the sophomore class and has nude photos of 16 or 17 different girls, nude or semi-nude, and is sharing them with his friends, then I'm thinking predatory behavior, criminal behavior, let's charge this kid and throw the book at him. And so, the first line of defense, I think, is let the adults make a rational decision about what the conduct shows. Does the conduct show stupid teenage behavior, or does the conduct show predatory behavior by someone who needs to be punished more harshly? So that's number one. Number two is if there's going to be a ban on prosecuting sexting, then you probably have to either have a standalone statute or some sort of carve-out that basically says that, in cases where it's, and again, I think it's hard to really codify, or you want to have, essentially the situation where it's one-on-one, it's hypothetical, and there really isn't any malice or intent or any predatory behavior. And I think what you're trying to do is define a negative instead of criminalize affirmative conduct. And so, that's why I think common sense prosecutorial charging decisions have to come first, and then an understanding of the kind of conduct that we're trying to potentially regulate. Now, I think the bullying example is a good one because there's a curriculum requirement that the State Board of Education has. They require all school districts to have a bullying policy, and then there are certain things that go into that policy that include counseling and proactive engagement. So I really think the solution here is not only educating students on their responsibilities when it comes to themselves and putting themselves out there in a vulnerable state, but also educating prosecutors and police about what is actually happening, and sensitizing them to what's again, stupid teenage behavior versus something that's much more pernicious.
So then maybe the answer, my kids have gone through that bullying in their school districts, and I know that they are, at least in Olentangy schools, they're very sensitive to other kids' feelings and respecting each other, and they have a pretty good code of conduct within the classroom. Maybe mandating an education program, a curriculum, is then maybe a part of something that needs to be considered.
Personally, I think that's the right approach. I think